Hello and welcome back to Mobile Health Industry Overview and the Evolving Regulatory Framework, a course and initiative by the UCSF-Stanford Center of Excellence in Regulatory Science and Innovation. In the previous module, I've presented on important and advanced topics related to the regulatory oversight of mobile medical health in the United States. We have learned about the role of the Federal Trade Commission and the regulatory trends in the broader health IT area of innovation, with emphasis on software as medical device and clinical decision support software. Last but not least, we have seen CDRH relevant regulatory science priorities that gave us clues on what to expect from the Food and Drug Administration in terms of also new guidance in the remainder of the year 2017 and beyond. In particular, we have seen how the topic of security is very high on the list of important topics at the Food and Drug Administration. We begin now a new module with the intent to go deeper on these and related regulatory questions and concerns about how patients' data are stored, used, and shared. Our focus will be on privacy, confidentiality, and data security, and more broadly on the complex issues around governance of health data. This is the last module of the course, and we will wrap it up with a brief summary and closing remarks. Let's begin our review of privacy, confidentiality, and data security issues in health data unconventionally by borrowing the words of British writer and philosopher Sir Arthur Charles Clarke. In An Enchanted Life, an Adept's Guide to Masterful Marriage by Patricia Telesco, Clarke was quoted to say, "I don't pretend we have all the answers, but the questions are certainly worth thinking about." This is very much how the health technology community at large feels at the moment about the topics of privacy, confidentiality, and security when thinking about the wealth of data that is being generated in conjunction with the exponential growth in the number of connected devices, mobile sensors, and apps, as well as in technology infrastructure that supports the recording and analysis of this data. The topics are creating much debate, and this is an area at the moment richer in opinions and questions than in answers. Thus, I intend to frame the conversation on the topics by sharing known and accepted definitions, by making the connection with the ongoing efforts around mobile health and health IT at the Food and Drug Administration and other agencies, and finally by recording on some of the most urgent questions according to our regulators and industry. The latter are bound to shape the debate in the years to come. When it comes to regulation of data, first off, we have to make a distinction between different categories of information, of which I'd like to present four for the sake of framing this discussion. Personal information means an individual's data elements such as social security number, driver's license number, credit or debit card numbers, and so on. It is personally identifiable information, or PII, if information associated with the individual person that is sufficient to allow identification of the individual, such as the patient's name, address, electronic mail address, telephone number, or social security number, or other information that alone or in combination with other publicly available information reveals the individual's identity. As such, personally identifiable information is considered sensitive. Personal information that is de-identified, that is maintained in a way that does not allow association with a specific person, is not considered sensitive. The category of medical information is information of possession or derived from a provider of healthcare service plan, pharmaceutical company, or contractor regarding a patient's medical history, mental or physical condition, or treatment. Building on the previous three categories, here we come to the most interesting definition for us: Protected Health Information, or PHI, defined by the Health Insurance Portability and Accountability Act as personal and individually identifiable health information that relates to 1. the past, present, or future physical or mental health or condition of an individual. 2, the provision of healthcare to the individual. Or 3, the past, present, or future payment for the provision of healthcare to the individual. Please consider the definition of personal information, personally identifiable information, PII, and medical information more as guidelines than anything else, as in reality, to make the topic of health data regulation even more complex, there exist different sources of regulations, a complex landscape of federal laws and regulations, as well as state statutory, administrative, and common laws. Not to mention the private contracts may set forth their own definitions. The category of information I'd like us to focus on in this lesson is Protected Health Information, PHI, as defined by the Health Insurance Portability and Accountability Act, also known as HIPAA. I'd like us to focus here for a few reasons. First, HIPAA is a United States legislation, and as such, it is where we have the best opportunity to set forth clear definitions and applicable privacy and security provisions for safeguarding medical information. Second, despite the fact that HIPAA is not new, there is substantial confusion in the mobile health and broader digital health sector that warrants spending some time presenting at least the basics of the legislation and attempting to make sense of the tumultuous relationship between HIPAA and industry. Obviously, not every digital health startup is subject to it, but most are, and not all even know it. Until Congress passed HIPAA in 1996, personal health information was too protected by a patchwork of federal and state laws, and patients' health information may have been distributed without consent for reasons not related to their medical treatment or healthcare reimbursement. HIPAA was created in the 1990s to set the following guidelines for the entire healthcare industry. 1. Healthcare records must be kept private and secure. 2. Continued access to health coverage through portability for those who change jobs. 3. Simplification through standard healthcare transaction formats. And at last, effective electronic transactions. It is important to bring emphasis to the fact that HIPAA privacy regulation protects only protected health information, or PHI, whose definition is worth repeating here and is fundamentally personal, individually identifiable health information, past, present, or future, related to a state of health or condition, to the provision of care, and to the payment of such provision. The birth of HIPAA coincides with the passing in 1996 of Public Law 104/191, which included administrative simplification provisions that required the U.S. Department of Health and Human Services to adopt national, uniform standards for electronic health record transactions and code sets, unique health identifiers, and security. At the same time, Congress recognized that advances in electronic technology could erode the privacy of health information, thus incorporated into HIPAA additional provisions that mandated the adoption of federal privacy protections for individually identifiable health information. HIPAA was created in 1996, but at the time of its origin, it was essentially a manifesto without enforcement provisions, and the legislation has evolved substantially over time since. In 2000, HHS published a privacy rule, which was later modified in 2002. A security rule was published then in 2003. In the years that followed, the enforcement rule provided standards for the enforcement of all the administrative simplification rules and marked a new phase in HIPAA compliance. Then in 2009, the Health Information Technology for Economic and Clinical Health, known as HITECH, was enacted as part of the American Recovery and Reinvestment Act of 2009, and made significant changes to HIPAA's administrative simplification provisions pertaining to privacy and security, including notifying individuals and, in some instances, media outlets when there has been a privacy or security breach. This is known as the breach notification rule of HIPAA. High-tech enforcement began in 2010, and new financial penalties have applied since. Then in January of 2013, the U.S. Department of Health and Human Services Office for Civil Rights announced the Omnibus Final Rule, which implements a number of provisions of the Health Information Technology for Economic and Clinical Health Act. It was done so to strengthen the privacy and security protections for health information established under HIPAA. And the new rule makes sweeping changes to improve data security, further restrict access to electronic personal health information, prevent the use of personal health information for marketing, and also enhances the enforcement rule. The Omnibus Rule took effect only a few months after, in March of 2013, and the healthcare industry was given 6 months to comply. I mentioned before that there is a great deal of confusion in the digital health industry, especially but not only in the entrepreneurial community, around HIPAA. And its in defense, the rather convoluted 20-year history of its making has been difficult for many to navigate. A useful framework for the sake of this course is to focus on two pillars of HIPAA: privacy and security. Health information privacy is defined as an individual's right to control the acquisition, uses, or disclosures of his or her identifiable health data. Please note that this is not to be confused with confidentiality, which instead refers to the obligations of those who receive the information to respect the privacy interests of those to whom the data relate. Borrowing the words of Simon Cohen, who was chairman of the National Committee for Vital and Health Statistics at the time of this definition, security is altogether different. It refers to the physical, technological, or administrative safeguards or tools used to protect identifiable health data from unwarranted access or disclosure. Most healthcare providers must safeguard privacy by following the HIPAA privacy rule, which sets a baseline of protection for certain individually identifiable health information. A major goal of the privacy rule is to assume that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high-quality healthcare and to protect the public's health and well-being. The rule attempts, in other words, to strike a balance that permits important uses of information while protecting the privacy of people who seek care. The privacy rule generally permits, but does not require, covered healthcare providers to give patients the choice as to whether their health information may be disclosed to others for certain key purposes, such as for the coordination and management of healthcare and the administration of benefits, and only on a need-to-know basis. Within the Department of Health and Human Services, the Office for Civil Rights has responsibility for enforcing the privacy rule with voluntary compliance activities and civil money penalties. The HIPAA privacy rule essentially implements known and recognized fair information practices, a term used to describe a set of standards governing the collection and use of personal data and addressing issues of privacy and accuracy. These practices exist well beyond just the healthcare industry, of course. All uses of information are known and appropriate. Individuals have a choice in how their information is used or disclosed. Personal information is protected and is used and viewed for business purposes only. And ultimately, what this allows is that personal information is accurate, relevant, and current. As mentioned in healthcare, striking a balance requires particular attention to ensuring privacy is protected, while not impeding in any way the flow of health information needed to provide and promote high-quality healthcare. Therefore, use of disclosure of personal information is allowed without individual authorization for certain key purposes, not limited to just situations requiring it for treatment, payment, and healthcare operations, but also, and for example, as required for research with Institutional Review Board or Privacy Board approved waiver, or in case of abuse, neglect, and domestic violence. Other types of disclosure may be either subject to notice and opportunity to object by the individual, such as a matter or disclosure to family and relatives or close personal friends, or otherwise subject to authorization. Some special considerations exist and are often widely misunderstood on the matter of disclosure to personal representatives or of psychotherapy notes, which is worth mentioning without going too much into detail in this course. Suffice it to say that relatively recent court decisions have clarified in rulings these HIPAA definitions and the circumstances in which disclosure is allowed with or without notice of consent. Whereas privacy has to do entirely with the individual's rights around certain health information, hence the privacy rule establishes national standards for their protection, security refers to the actual physical, technological, or administrative safeguards that are actually used for protecting certain health information that is held or transferred in electronic form. Hence, the security rule operationalizes the protections contained in the privacy rule by addressing these safeguards that certain organizations must be putting in place to secure individuals' electronic protected health information, also known as EPHI. Within the Department of Health and Human Services, the Office for Civil Rights has responsibility for enforcing also the security rules, with voluntary compliance activities and with civil money penalties. Prior to the birth of HIPAA, no generally accepted set of security standards or general requirements for protecting health information truly existed in the healthcare industry. However, technology was also such that the risks, however serious, were quite contained in a way. After all, the flow of information through the 1990s was essentially all based on paper. The new technologies then started evolving, and the healthcare industry began to move away from paper processes and rely more heavily on the use of electronic information systems to pay claims, answer eligibility questions, provide health information, and conduct a host of administrative and clinically relevant functions. Today, providers are using computerized physician order entry systems, electronic health records, radiology, pharmacy, and laboratory systems, and health plans are providing access to claims and care management, as well as member service applications. Not only administrative and health management functions as before, but now mobile health and medical devices and other connected systems with health or medical intended use are both using and creating new data. While this means that the medical workforce can be more mobile and efficient, the rise in the adoption of this technology has also created a growing number of pains and security concerns.